We are live.
Hello, good evening, everyone. I welcome you all to the 43rd episode of the AIOS ARC PG teaching program, which is an initiative of the Academics and Research Committee of AIOS. Through this PG teaching program, it is our endeavor to focus on topics and subjects that are relevant for the PG students, but are not easily covered and not easily found in standard textbooks and study material. One such aspect is the barely touched upon topic of medico-legal aspects in ophthalmology, which is hardly touched upon in the PG curriculum. A thorough understanding of the regulations governing ophthalmologists, their implication in everyday practice, and steps to safeguard against lawsuit is the need of the hour, which all of you will agree. So to give you an insight into all of this, we have organized this webinar. And I'm sure it's going to be very useful for the PG students attending, as well as for the other ophthalmologists in their daily practice. To speak on the medico-legal aspects of ophthalmology, we have with us Dr. Ashok Nataraj, a vitreoretina consultant practicing at Precise Eye Care Trivandrum. He is also a qualified lawyer. He's just finished his law degree, and I think he's the most appropriate person to give us an insight into all these aspects. We also have a stellar panel of discussants with us. We have Dr. Prakash Marathe sir, who's a consultant at Netra Yogi Eye Clinic, Pune. Dr. Marathe has also served as Senior VP of the IMA Maharashtra, and he has a great insight into tackling medico-legal problems. So we're looking forward to your input, sir. Thank you so much. Sir?
Thank you so much.
Pleasure, sir. Pleasure to have you, and thank you so much for being here. We also have Dr. Kedar Nemiwant, who's an Associate Dean and Head of the Department of Ophthalmology at the All India Institute of Medical Sciences, Rajkot. So welcome, Dr. Kedar. We look forward to your participation, and it's really nice of you to spare time to be a part of this webinar. We also have with us the very dynamic Dr. Arvind Kumar Maurya, who is Additional Professor and Head Department of Ophthalmology at the All India Institute of Medical Sciences, Hyderabad. So as always, you're full of new ideas, a very innovative person. We look forward to your inputs. Welcome, Dr. Maurya. So again, I welcome our speaker and all our panelists. I also welcome the audience who is logged in tonight, and I request the audience to please keep their questions coming. Let's make it as interactive as possible. It's a very good opportunity to get all your doubts cleared, get all the knowledge possible on this topic. So I request the audience to keep posting their comments, their questions in the chat box. And without much ado, I now invite Dr. Ashok Nataraj. His talk will be divided into two parts. One will be the general medico-legal aspects, and the other will be the doctor-lawyer interaction. So over to Dr. Ashok Nataraj.
Good evening, everyone. I'm Dr. Ashok Nataraj. I'm a practicing vitreoretinal surgeon working in Trivandrum. Now, I just recently completed my LLB. I'm really thankful to AIOS and especially Dr. Prashant Bavankule for giving me this wonderful opportunity for a talk on law for doctors. So whether you're a postgraduate or whether you're a practicing surgeon, it doesn't matter. As far as law is concerned, it is equally applicable to everyone. And as postgraduates, it's very important to know the legal aspects of medicine because you're just starting your career. And if you take all the precautions right now, you can have smooth sailing ahead. Now, why should we talk about medical negligence? Because, it is always said that majority of the morbidities that happen in patients, according to the Journal of American Medical Association, is because of error of judgment or making mistakes as far as diagnostic tests are concerned, etc., etc. So as far as doctors are concerned, there is always a risk that patients can file cases of medical negligence against you, stating this and that. And if you look at United States of America, the lawyers are given permission to solicit saying that suppose you have ROP and the child has lost vision. There are advertisements saying that you come to us, we'll get you a lot of compensation. So in such a scenario, it is very, very important as a doctor that you know your liabilities and how you can protect yourself against all these unnecessary situations and unnecessary complaints that patients can make against you. Now, what do you mean by negligence? The first thing is that as far as a patient and a doctor is concerned, when they come to you for treatment, there is a silent contract between you and the patient. The patient gives you an offer and you accept it. You have a duty of care. That is, there is a contract between you and the patient. So the first aspect of medical negligence is there should be a duty of care between the patient and the doctor. The second thing is you have a duty of care, and there is a breach in this duty of care. And the third aspect of medical negligence is because of this breach in duty of care, there is resultant injury to the patient. So this is the three aspects. So not only there should be a breach in duty of care, not only that you have not properly treated the patient, because of your improper treatment, there should have been some injury to the patient. Then only you can be held liable for medical negligence. So that is the three aspects of medical negligence. So these are the mistakes and negligence, failure to perform tests, wrong treatment, medication errors, misdiagnosis. So these are the common things that can come under medical negligence. Now, what do you mean by standard of care? Now you say, I said duty of care. It is not only duty of care, that what kind of treatment that are you providing to the patient? So standard of care doesn't mean that expert care or superlative care. It just means average care that is expected of an average doctor in your situation. So it doesn't mean that, you're not giving the 200% care that a genius in your field can give. It just means average care. So suppose you are a cornea surgeon, a retinal detachment patient comes to you. It doesn't mean that you should do a retinal detachment surgery. You can just refer the patient to the retinal surgeon, and the cornea surgeon cannot be held liable for medical negligence. Now, what are the liabilities that a doctor have as far as medical negligence is concerned? One is civil liability, another one is criminal liability, the third one is liability under torts. Then you can have disciplinary action from our National Medical Council or the Indian Medical Council, and the last one is the concept of res ipsa liquitor. Now, civil liability and liability under tort are similar. Civil liability means for a wrong, for that particular wrong, the compensation is, or compensation as far as the damages that the patient has undergone is paying some money. So for civil liability and liability under tort, the remedy is compensation in the form of money. The second aspect is the criminal liability. And the next one is disciplinary action. Suppose, you have the National Medical Council, which has given guidelines how a doctor should be acting or how a doctor should behave in this particular country. If there is any deviation from that path, the National Medical Council can take action against a doctor. It means suspending him from being a doctor, or suspending his license, etc., etc. Now, the last one is the res ipsa liquitor. Res ipsa liquitor means the truth speaks for itself. Actually, in a normal situation, the petitioner or the patient has to prove that the doctor has been medically negligent. In this particular condition, what happens? It becomes a duty of the doctor to prove his innocence. For example, a doctor does a surgery, an abdominal surgery. He leaves scissors in the abdomen. He forgets to take it back. After some time, the patient comes back with stomachache. It is found that scissors is there inside the patient's abdomen. Now, the scissors has no place to be there inside the abdomen. Now it becomes a doctor's responsibility to explain why he is not medically negligent. So that is the most important thing. Now, as far as liabilities of doctors are concerned, 99% of the liability is only civil liability or liability under tort. That means the patient says, you have treated me wrongly. For that, you please give me damages in the form of money. Criminal liability is less in the sense it's not very common, especially in ophthalmology, where we don't deal with a lot of deaths, etc., etc. Criminal liability is less. And disciplinary action only in exceptional cases when the patient directly gives a complaint to the National Medical Council. And res ipsa liquitor, it can happen to anybody. Now let us come to criminal liability, because there has been some confusion as far as criminal liability in doctors are concerned, because recently there has been a confusion that doctors, according to the new act, that is The IPC, as you know, is now being replaced by the BNS or Bharatiya Nyaya Samhita. According to the new act, doctors are not criminally negligent, but this is not true. I'll just throw some light on that. Now, as far as criminal negligence is concerned, one section of the Indian Penal Code that doctors come under is 304A of the IPC. It means rash and negligent act leading to death of the person. So, for a normal person, any amount of rashness, any amount of negligence, it's not quantified. When it leads to death of a person, the person can be held criminally liable under 304A of IPC. And this negligence need not be substantiated by anybody, or if it is there or if it is alleged to be there, the person can be booked under 304A of the IPC. But as far as doctors are concerned, there are two leniencies that has been given. It has been stated well in the Jacob Matthew versus State of Punjab case in the Supreme Court. For a doctor to be held criminally negligent under 304A of IPC, the negligence should be gross. It doesn't mean just negligence. It means gross negligence has to be proved. And the second thing is that not only gross negligence has to be proved, it has to be that gross negligence, the existence of gross negligence has to be substantiated by another competent doctor. Only if these two things are present, only then a doctor can be booked under criminal negligence under the act under section 304A of IPC. So according to 304A IPC, death due to rash and negligent act, the doctor can be imprisoned for a period of 2 years. So this is the basic thing. Now, as you know, by July of this year, Indian Penal Code is going to be replaced by the Bharatiya Nyaya Samhita. Okay, so 304A of the Indian Penal Code will be replaced by 106 by section 106 of the Bharatiya Nyaya Samhita. So according to the Bharatiya Nyaya Samhita, the quantum of punishment for death due to rash and negligent act has been increased from 2 years to 5 years. But as far as a registered medical practitioner recognized by the National Medical Council Act of 2019 is concerned, this criminal liability has been reduced for doctors. It is not that doctors are not exempt, but the amount of imprisonment is not 5 years as for any common person. It is only 2 years for a doctor as far as a doctor is concerned. And for a doctor, there is not only an imprisonment of 2 years, but there is also a mandatory fine. So these are the two leniencies that has been given to doctors. For a normal person, according to the new rule, he can be imprisoned up to 5 years, according to the new rule. But as far as doctors are concerned, it is not 5 years, but only 2 years, but along with a mandatory fine. Now, what are the other criminal liabilities that a doctor has under the Indian Penal Code? The other one is section 337 and 338 of the Indian Penal Code. It means hurt and grievous hurt due to gross and negligent act. It is not only death, but if that rash and negligent act causes hurt or grievous hurt, then also a doctor is criminally liable. Now, what are the differences that a doctor can claim in such a situation? He can say that, I did it in good faith. I never intended to harm the patient. And the second thing, I have always taken a consent. The patient knows that these are the risks involved, and still he decided to go along with me, and it is not my fault. So these are the differences that a doctor can take in case of criminal negligence. Now, courts have always recognized the situation that the doctors are in. Court says, doctors are not gods. They cannot assure 100% result in all the cases, but they should perform their work with a reasonable skill that an average doctor in his position is expected to do. So that is all the court expects. You should not think that, if the patient is not cured, you will be held liable by the court if you have done things properly. Now, how can a patient go for a redressal of his complaint? Okay, but patient has a complaint against a doctor. How can he get redressed of his complaints? Now he can either go to the civil court or the criminal court. He can go to the consumer protection courts under the Consumer Protection Act. He can go to the National Medical Council so that it takes disciplinary action against the doctor. He can even go to the Permanent Lok Adalat. Even other avenues like vigilance, or he can go write a letter to the chief minister saying that such and such a thing has happened. All these things are possible. But normally in a medical negligence case, patients or complainant, they go to the consumer protection courts and not to civil and criminal courts. So I'll tell you why this is so. Now let us come to the Consumer Protection Act. See, the recent Consumer Protection Act is the Consumer Protection Act of 2019. And it is according to the Act that the Consumer Protection Forum in India has been established. So the Consumer Protection Forum is a 3-tier system. One is at the district level, the other one is at the state level, and the third one is at the national level. So it is the District Consumer Protection Forum, State Consumer Protection Forum, and the National Consumer Protection Forum. So up to 1995, doctors didn't come under the Consumer Protection Act. It's only after the famous case IMA versus VP Shanta where doctors included under the ambit of the Consumer Protection Act. So the basic thing is a consumer is a person who seeks a service after paying a particular fee. So anybody who does that comes under the Consumer Protection Act. So as far as a doctor is concerned, he gives medical services, and in lieu of that medical services, he takes fees from the patient. So he also comes under the Consumer Protection Act. Now, let us go a little bit into the nuances of the Consumer Protection Act. So if a doctor if a patient gives a case against a doctor under the Consumer Protection Act, where will the case be held? Whether it will be held in the district forum, state forum, or the national forum. One of the factors that decides that is the pecuniary jurisdiction. Pecuniary means something related to money. So the amount of money, that compensation that has been claimed by the patient, that will determine at what court the particular consumer protection, the case given in the Consumer Protection Forum is held. So if the patient asks for up to 50 lakhs compensation, the case will be held in the District Consumer Protection Forum. If the compensation claimed by the patient is between 50 lakhs to 2 crores, the case will be run in the State Consumer Protection Forum. If the claim is for more than 2 crores, then the case will be run in the National Consumer Protection Forum. Now let us go into some more nuances of the Consumer Protection Act of 2019. Now the first thing is controversy regarding whether medical negligence comes under this particular act or not. See, in the Consumer Protection Act of 2019, the medical services has not been explicitly mentioned. But for a particular act to exclude a particular group of people, the exclusion criteria is usually clearly mentioned, but nowhere in the act it is mentioned that doctors don't come under the purview of the Consumer Protection Act. So for all practical purposes, doctors are included under the Consumer Protection Act of 2019. And the second thing is something called as limitation period. Suppose a patient has a grievance against you. There is a time period within which he has to file the case. If he crosses that particular time period, then he cannot file a case against you. So as far as the Consumer Protection Act is concerned, this limitation period is 3 years. That means there is something called as cause of action. Cause of action means the act that leads to injury, which is the cause for the patient to give a case against you. So the case should be filed within 3 years of the cause of action. But there is a rider to that. All these things are decided by the judges. It is the discretion of the judges that decide whether a particular case will be accepted in the court or not. Suppose a patient says, I was indisposed. I could not give a particular case because of so many reasons. Then that limitation period can be extended, but that depends on the discretion of the judges. Then, when a court accepts a case, from the complainant or the patient, what the court will do is it will send a summons to the concerned doctor. That is a written statement that is a written document or a legal document sent by the court. What it will ask is, it will ask reply from the doctor, stating that such a patient has said so many things against you. Now you tell me your part. What is the reason? You tell me why this has happened, whether he's right or wrong. You tell us your part of the story. So that is called as a summons. That is a legal document asking for the doctor to appear in the court or give a reply to the complaint filed by the person in the court. Now, the important part is, according to the Consumer Protection Act of 2019, this reply has to be filed by the doctor within 30 days. A 15-day grace period is also given so that the reply must have reached the court within a period of 45 days. Suppose you don't file a reply within 45 days, what will happen? It means that you will lose the chance of arguing the case. your part of the story will not be heard by the court if you don't file the reply within 45 days. The case will be decided ex parte. That means whatever the complainant has given, based on that and that evidence, the case will be decided. So that is very important. Suppose you get a summons from the court, it is very important that you reply within a period of 30 days or a maximum of 45 days. Then another rider, as far as Consumer Protection Act of 2019 is concerned, suppose the district forum awards damages against you, or you are supposed to pay a few crores of rupees to the patient. A judgment comes against the doctor. So the remedy the doctor has is he can go for appeal to the next higher forum. So suppose the district forum has taken a stance against the doctor, he can go for appeal to the state forum. If the state forum has taken a stance against the doctor, he can go for appeal to the national forum. And if he fails the case in the national forum, he can go to the Supreme Court with the appeal. So that is the highest court that a doctor or a person who has lost his case can go in the Consumer Protection Act. So earlier, what happens is if you lost the case in the district forum, you just can go for appeal to the state forum. Not much of monetary loss is incurred by the doctor. But according to the Consumer Protection Act of 2019, 50% of the awarded amount has to be paid by the doctor in the forum before he can file an appeal. So suppose 1 crore has been awarded as compensation, 50 lakhs has to be has to be deposited in the court by the doctor before he can file an appeal to the higher court. So that is one draconian measure that is against the doctor in the Consumer Protection Act of 2019. Another important thing is, I was telling you why people don't file a case in the civil court and they file a case in the Consumer Protection Act. So the importance is the filing a case in the Consumer Protection courts or according to the Consumer Protection Act is a very simple affair. There are no formalities involved. You can just file the complaint in a plain sheet of paper, and it can be even filed online from any part of India. See, for a civil case to be filed, 10% of the compensation claimed has to be given as court fee. Suppose you claim a compensation of 1 crore. 10% of 1 crore has to be deposited in the court before you can file the case. So that is a huge burden to the complainant. But in the Consumer Protection Court, that is not the case. Suppose you claim a compensation of even more than 2 crores, just about 5,000 rupees is the court fee that the person has to pay in the Consumer Protection Court. So it becomes a very simple affair as far as the consumer is concerned to go against the doctor. Another thing is he can file a complaint online from anywhere in India. Suppose he files a case from West Bengal. Okay, now the poor doctor has to go to the court in West Bengal to fight the particular case. So it becomes easy for the complainant, but it becomes very, very difficult for the doctor as far as Consumer Protection Act of 2019 is concerned. Now we just talked about the liabilities and how the complainant or the patient can go against you. Now, what is the protection available for the doctor as far as medical profession is concerned? Now we have 2 schemes. One is the Professional Indemnity Scheme, and another one is the Professional Protection Scheme. Professional Indemnity Scheme is run by insurance companies. Professional Protection Scheme is run by Indian Medical Association. The difference is you must understand Professional Protection Scheme is always superior. So what are the advantages of the Professional Protection Scheme? Now, Professional Protection Scheme is a scheme run by doctors of the Indian Medical Association. This gives you legal help, including lawyers, and they help you in preparing the reply and how to approach the particular cases. The second thing is Professional Protection Scheme includes even criminal cases. It not only involves civil cases, it also covers criminal cases. And the third thing is Professional Protection Scheme is for justice and not for settlement. See, Professional Indemnity Scheme means you pay a certain premium to an insurance company. And when you get a case against you, they will give you a promised amount. And with that amount, you have to run your own case. You don't get any other help. And this money cannot be used for criminal negligence against the doctor. So this is a very bare scheme as well as professional indemnity is concerned. But the Professional Protection Scheme run by IMA is not like that. It can even that the money that is promised by the Indian Medical Association when you join this particular insurance scheme is used even for criminal case, can be used even for fighting criminal cases, And it gives you legal help, because IMA has a group of lawyers who fight these medical legal cases all the time, so they have more experience. And the third factor, I said, for justice and not for settlement, it is very important, because suppose you lose the case and you have to give, suppose, 1 lakh for 1 lakh as compensation. Suppose you are part of the professional indemnity scheme, they don't encourage you to go for an appeal, even though you are in the right. What they'll do is they'll just settle the case and move forward. But the professional protection scheme of IMA is not like that. Even if it is a small thing, compensation that the doctor has to pay, they still go for appeal, because the doctor is in the right and they fight for justice and not for settlement. So always professional protection scheme, especially run by the Indian Medical Association, is better than the professional indemnity schemes that are run by other insurance companies. And what are the defenses that the doctors can offer in case a medical negligence case comes against them? One is known complications, difference of opinion. Difference of opinion means for a particular case, it might not be clear. There can be a lot of differential diagnosis. So one doctor might treat one differential diagnosis, the other doctor might treat the other differential diagnosis. That is not medical negligence. Then unexpected and unforeseen negligence, contributory negligence. Suppose a patient has not taken enough care. He has contributed to the negligence. That can also be a defense for the doctor against medical negligence. Then emergency care, then consent of the patient. But having said all that, just because the patient has given consent, it doesn't mean that he has given consent for you to be medically negligent. So what the court will look is, have you taken adequate precautions? Have you taken the reasonable standard of care that is expected of an average doctor in that particular situation? Thank you very much for your kind attention.
Thank you, Dr. Nataraj, for giving us a very well-rounded overview of the medical legal aspects that concern us all. So I'd like to invite the panelists to give their comments and any inputs that they want to. Dr. Prakash Marathe, sir, anything that you would like to add to this?
I must congratulate Dr. Ashok Nataraj for the wonderful talk given on medical legal aspects. First important thing is that this particular topic, most of the times, when we were undergraduates and postgraduates, it was not covered in medical colleges. But now it is the time that one must know everything about medical legal aspects. That's what he has covered. What important thing that we have to keep in mind, it is not no cure or no care or differential diagnosis problem. In case of ophthalmology, important thing what you have to remember, you may be in medical legal trouble, that is the rare complication, which is death. And death has to be tackled in a nice way, proper way, perfect way. And one important thing is wrong eye to be operated. Wrong eye where the treatment is given. There is no excuse for these conditions. And for these things, when you are asking for help, lawyers are not the people, those who are helpful in these situations. Doctors are not sufficient to help you out, but it is the third entity, that is medical legal experts. The doctors who are lawyers, they really know the scenario, they really know that particular language, medical language, interpretation of all those particular instances. And you must take help of medical legal experts. They are available in each and every city at IMA platform as well as ophthalmology platform. One important thing that you must remember, it is the consent and documentation. Whenever there are medical legal issues, the thing which saves you is if you have taken proper informed consent, and important thing is documentation. So whatever is written is done, whatever is not written, it is not done. So the thing which saves you in the court of law is documentation, documentation, and documentation. One important thing about CPA 2019, CPA was there, but in 2019 CPA, important thing what they have changed, just I will summarize additional things, what Dr. Ashok has said. Jurisdiction can be different. You have treated the patient in Delhi, but patient is in probably Tamil Nadu. He can lodge the complaint in Tamil Nadu, and probably doctor might have to run to that place, which was not there in the previous previous CPA. Second thing is, though there are various levels like district, state, and national commission forum, and the amount is different, In CPA 2019, what they have done is the billing issue. The patient and relatives can complain in relation to bills. And luckily in ophthalmology, there are no bills which are in crores and even lakhs. So that way ophthalmology fraternity is saved from that particular aspect. One important thing is in the past, IPC 304A, which has to be differentiated from 304. At various places, police officers used to take doctors under custody by telling only 304A, which was non-bailable. But 304A is bailable. And most of the police inspectors were not knowing about 304A, but they were applying this clause of 304, which was totally wrong. And now the new law has come, what Dr. Ashok has explained in a nice way, that is BNS 106. But in the past, there was misuse of 304. And interpretation of 304A was properly done at various platforms like IMA. Even at Pune, we had faced that difficulty and we had helped our members. And I think with these additions, there are so many things he has covered in a nice way. Thank you for allowing me to put my views. Thank you so much.
Thank you, Dr. Marathe. Dr. Kedar, would you like to comment on this?
Very excellent topic and very useful and very much neglected topic. Just I will add, want to add two things. The professional indemnity is must, and you should become, and you must become the member of association, like a AIOS, like IMA. This is actually must, and you should not lose talks about your colleagues. This is a very, very important, and that should be teach. That should be teach. It is neglected part nowadays, but that is a very, very useful for a long-term future. Thank you.
Thank you. Dr. Maurya?
Yeah,
Your
so it
comments?
was an excellent talk, Dr. Natarajan. So let's talk about the practical aspect and discuss on those things. So there is this PC rent happened and the surgeon put a 3-piece IOL in the sulcus, right? And he instilled intracameral pilocarpine. And because the patient was high myopic, RD happened. And the doctor was held liable. So I want insight from Dr. Natarajan and Marathe sir.
Thank you very much, sir, for the query. I'm Dr. Ashok. Actually, complication is not negligence, because when we take a consent from the patient, we explain the patient of all these complications that can happen. The only thing the court will see is whether that complications has been handled in the way it should have been handled. Whether reasonable care or reasonable standard has been applied in handling those complications. There is something called as a Bolam test and Bolitos test. That is what Indian courts follow. Bolam test is what Indian courts follow. What it says is, in that particular situation, another colleague of yours, would he have done the same thing or would he have done things differently? Suppose, you can substantiate it with textbook evidence saying that this is how things should have been done. You cannot be held negligent for this thing that, as you said, because 3-piece IOL was put, pilocarpine has to be put. That is the norm and that is the way it should be done. Doctor cannot be held negligible. The only thing is, all these things should be presented properly in the court of law by a competent lawyer, and all this help the doctor only can convey to the lawyer. The lawyer doesn't know all these things. So it is most important that you should sit with the lawyer, explain everything and say that you are the right.
But the doctor was, the surgeon was held liable for this mistake, that if the pilocarpine was not instilled, this complication might not have happened.
Sir, it's like, no, you have to get some expert from your field to say that this is how things have been done. And second thing,
So now you are
textbook
coming
evidence.
to my
Textbook
main,
evidence.
yes, absolutely, Dr. Ashok.
Yes.
So the court, they are not allowing the ophthalmologist, senior ophthalmologist, to be as an external advisor. That is lacking in our judiciary system.
No, sir, I'll tell you about that also. Because, see, expert opinion or expert panel is the discretion of the court. What the court
Exactly.
feels is,
So
yes,
most of the time they are not allowing the.
No, I'll tell you the nuances of that. Expert panel is the discretion of the court. What the court feels is, doctors are all in cahoot with each other. If you call another doctor, he's only going to support this lawyer. So let me look at the facts of the case and let me decide for myself. That is what the judge will say. But there is another option. What you do is you can file an affidavit. Like you can get an expert in the field and file an affidavit. You can file that opinion in the form of an affidavit, which the court will accept. And the second thing is the expert opinion has to be provided by the complainant and not by the doctor actually. Because the complainant has to prove, the patient has to prove that the doctor was in the wrong. So actually the complainant has to get an expert witness to say that, this person has not followed the standard of care. This expert panel, usually it's the discretion of the court whether to allow it or not. But an expert opinion can be filed in the form of an affidavit. And again, it is the duty of the complainant or the patient to file an expert opinion because he has to prove that the doctor is in the wrong.
And
May I come in?
yeah, Marathi sir, please.
Yes, sir.
Actually, what you have said, that procedure can go differently in different doctors' hand. Only the thing is justification has to be there from the books. And whatever the way you are treating, probably there has to be some justification. And what Dr. Nataraja said, what common doctor, normal doctor will do in that situation, if you have done that, it is not negligence. And what you are supposed to do, if you have not done that, again it is negligence. But otherwise it is not. Another thing is about expert opinion, what you are talking about. In the cases of 304 and 304A, in our city and in our state, when such cases happen, I think that particular police officer asked that particular judge and to have that expert committee. Most of the time, this expert committee is from government medical college. And the doctors from government medical college, they are on the panel. And unfortunately, that particular panel is being asked the questions such as multiple choice questions. Whether there will be blindness because of that, whether the person will be dead because of this. And there is no explanatory answer to that. Unfortunately, it is MCQ type of answer, yes or no, which doesn't explain everything in a proper way. And police officer says, see, this is the report of expert committee panel, and hence you have to be arrested. So that is the unfortunate thing what you have said. Another answer to a question is probably in different court of law, probably with different judge, the result may be a little different. Only the thing is, your lawyer must be medical legal expert, or if he's not medical legal expert, probably that particular lawyer has to be very well supported by medical legal expert. So that explanation in court of law has to be done perfectly, probably will save the doctor.
And as sir was saying, that point regarding criminal negligence, one, there should be gross negligence. That is what the court says. And second, as sir said, an expert in the field should say that, the doctor has been negligent. He should contribute to the evidence. So this gross negligence and simply negligence, that differentiation, that is a gray area.
One more example, there were 5 cases that were filed against the ophthalmologist for negligence. And they were proven not guilty in the law of court. But media trial was done by a national media house. I won't take the name. And even after they were proven not guilty, the media house then come forward and said that it's their fault that they did this media trial against that surgeon. So what are the laws against such media personnel? These kind of media houses? Any laws there?
Unfortunately, sir, there is only one law. You can only file for defamation. There is no other law against media person. That is an unfortunate. You cannot even file a temporary injunction saying that
Exactly.
because it is false. You don't publish all these things. That also is not possible because it's against freedom of speech, fundamental right. So the only remedy is go for a defamation suit, and that you have to pay 10% of whatever defamation you have asked for from the person. First, you have to deposit 10% of that. You have to run behind that. It is a very, very, very tedious process. So I think they get scot-free most of the time.
But it's very
I
time
think in the yeah. Sorry.
Marathe sir?
Continue. I think it is the unfortunate scenario in our country. Apart from civil, criminal, police, each and everything, there is media trial. I think media trial is so fast that when the case comes in the court of law, before that, the media is trying to give the judgment. That is an unfortunate thing in our country. Probably what Dr. Ashok has said, defamation is the one thing that you can go against and you can file the complaint. But in our country, that is an unfortunate scenario. It happens with each and every profession. Media trial is there. And I think you really cannot do in that particular case.
So
you have to just
IMA
play your own cards. You can play your own cards. You also can go on the media. You can go also on the TV in the debates, and you can defend your case. And you can say the press notes like in the newspapers saying that this was not the situation what media has been saying. This is the situation. And this is what IMA Pune says. This is what IMA Maharashtra says. This is what AIOS says. And you should be in support of our doctors and medical fraternity in such situation that what media trial has been done is not correct.
So, Marathe sir, I want to ask you what IMA and what AIOS can do at their end for protection of the
Actually,
surgeon.
we have got legal committees at IMA level, even local level, state level, national level, and the same way at ophthalmology level. In Pune, we have got one pediatrician, lawyer pediatrician, Dr. Jayant Navarange, who is very helpful to all IMA members, apart from Pune, Maharashtra, as well as national level. And Dr. Anand Deshpande, who is ophthalmologist, also helping in the state of Maharashtra. Dr. Kedar knows him very well. Now, in this particular scenario, there has to be one cell at each district, at each branch of ophthalmology society and IMA. And whenever the member is in particular the trouble in that particular situation, I think you have to help. We have got rush teams in our city. Whenever such situation occurs, probably 15 doctors, they rush at that particular site, try to avoid the violence. And whatever, this I remember when I was IMA Pune president, there was one case of Boviron injection reaction, and the doctor was under jail, and that was 304. We went to the commissioner of police. Rashmi Shukla was the commissioner of police that time. Our medical legal committee went to that Mrs. Rashmi Shukla, explained her that 304 and 304 is different. And that commissioner of police, Rashmi Shukla, told that police officer that what 304 you have applied is wrong. It had to be 304A, and that way that doctor was released. Here the role of IMA was very important. So only one doctor cannot do, and most of the ophthalmologists and doctors, what they feel that they are very clever, they are very rich, they are safe in their premises, they are safe in their clinics and their hospitals. This is not correct. They have to be the members of various associations. They have to come and they have to be in the close groups. And whenever they are in trouble, probably there will be the help which they can ask to their seniors, then their city ophthalmology and IMA societies and associations, when they can help them, because there are medical legal cells which will help each and everyone. That's what I feel.
And right.
Thank you, Dr. Marathe, sir. So we have another talk by Dr. Ashok Natraj, so we'll have to move on to that. Thank you for the great inputs. And one point that really strikes is that our documentation has to be perfect, so that whenever you have a complication, you can demonstrate that what you did was the standard of care. So documentation has to be perfect in any case, especially if you encounter a complication. So with that, thank you, Dr. Kedar and Dr. Maurya also for your great inputs. And we move on to the next talk, again by Dr. Ashok Natraj, and he'll be speaking on the aspects of doctor-lawyer interactions. Over to you, Doctor.
Good evening, everyone. We'll just come to the next part of my presentation. This is also very important. This is about doctor-lawyer interaction in a medical legal case. Suppose you get a medical legal case, the first thing you do is you have to meet a lawyer. So it's very important to know how you're going to interact with him in a medical legal case. So, as I already said, see, medical legal cases are increasing. Many of them are frivolous. And the chances of you having an interaction with a lawyer is all the more in the present setting. Now, the most important thing you must understand is, lawyers usually don't come under the Consumer Protection Act. See, as a patient, as a doctor, you have a responsibility to the patient. If you're not properly taking care of him, he can give a case against you. He can do a lot of things against you. That is one of the safeguards that the patient has, and that is why doctors are even more careful while they deal with patients. So such things don't exist with a lawyer as far as a lawyer is concerned, because see, they cannot be held negligent. If they don't run your case properly, they can never be held for negligence under the Consumer Protection Act. And there are a lot of safeguards that they have. The only thing that they can do is, they can be held for professional misconduct. The bar council can suspend them for a few months or a year or whatever. So, see, when you get a case, it is your case. The lawyer is only an intermediary or go between, so that he can present your case properly in the court of law. So it is actually you who have to run the case. Like, you have to go behind the lawyer, make sure he's doing things properly, give him all the help, tell him your viewpoint, because the doctor is not a medical person. If you don't really push him, or if you don't talk to him, or if you don't clear your point of view as far as, doctor is concerned, or you should make him clearly understand the defenses that you're putting forward, only then you can win the particular case. So the involvement of a doctor in a medical legal case is all the more important. You cannot say that now I have a lawyer, I have given him my case, now it is his duty to win the case. So unlike medical profession, it becomes the duty of the doctor also in a medical legal case to fight it, because his survival depends on that. So the most important thing is vigilantibus non normandibus jura sub benuint. It means law assets only the vigilant. So you have to be always vigilant in a medical legal case as far as the doctor is concerned, so that all the points are covered and he makes sure the lawyer runs the case properly. And being vigilant helps in avoiding medical legal cases also. Now, the rule 1 as far as doctor-lawyer interaction is, please try to avoid interaction with lawyers, because I have completed LLB. It is better not to have unnecessary interaction with lawyers. Now, I'll just tell you the various processes, that are involved in a medical legal case. Suppose a patient has a grievance against you. The first thing he is going to do is he is going to send you a legal notice. See, legal notice is not actually a formal case or something like that. It is like a threatening letter from the patient. So what he'll do, he'll take the assistance of a lawyer. And the lawyer will send a communication to you saying that, doctor, you have done this kind of wrong to my patient. If you don't pay this much amount to my client, this patient, we will take legal proceedings against you. This is a warning, and this has to be done within this amount of time. See, first thing is, the language that lawyers use, they'll be very disheartening. You will feel totally, you'll feel totally drained when you see all that and all. You should not be bothered. So once you get a legal notice, it means the patient is planning to take a legal action against you. A legal notice doesn't mean that a legal process or a legal course of action, a formal legal course of action is against you. It is only a kind of threatening letter or a forewarning from the patient or a person who's giving a complaint against you, saying that if you don't do this and this thing, if you don't give me this much money, I'm going to take legal action against you in the court of law. Now, what should you do? What should you do when you get a legal notice? See, as far as a doctor is concerned, when he sees this letter, he'll feel totally drained, because he has treated the patient with all his, sincerity and goodwill, etc., etc. And to see such a language from a patient he has treated, most of the doctors cannot bear it. So the first thing what they'll do is they'll call their lawyer, who is a friend, a very close friend of theirs. See, this close friend lawyer's son was sick. And in the middle of the night, he has called you. You have immediately rushed to the lawyer's house and taken care of that child. Now you have an emergency, you call the lawyer. The way in which the lawyer will react, you should not be surprised. What he's going to tell you is, doctor, I'm right now busy. I'm in a marriage. You can come tomorrow morning at 11 o'clock in my office, then we can talk. So when you get a reaction like that from the doctor, I should advise you that this is how that profession works, and you should not be upset. You should not be, worried that what will happen to me. See, you have your viewpoint, you have the court of law, you have the forum to present your case. So you should not be unnecessarily be worried. You should always be very objective, and you should not be offended. When you have a legal notice, when a case is there against you, you should not be offended by the behavior of people around you, because that is how the system works. You should always be objective and brave. And when you get a legal notice, you should understand you are alone in that particular case. You cannot expect anybody to have an involvement more than you have. So you should be very objective when you get a legal notice. Now, what should you do when you get a legal notice? The important thing is, when you have a legal notice, you should always reply to the legal notice. So to reply to a legal notice, you need a good lawyer. So the best thing is, see, as far as law is concerned, the first shot is the best shot. So you should get the best lawyer that you can afford. What happens many a time, the initial phases, the people who are fighting cases, they are not very much oriented. They get not very good lawyers. They look out for less money, etc., etc. And what happens in the initial trial itself, the case is not run properly. Now, when the case goes for an appeal to the higher court, then the person wakes up. He feels, no, the first time I've not hired a proper lawyer. Now I'm going to hire an even better lawyer. So there is a principle of law called as constructive res judicata. See, in the constructive res judicata means whatever facts you are presenting in the initial case or the initial hearing or the first phase, that much facts only you can present. In an appeal, it is only based on not based on facts, but only in the question of law. See, an appeal is decided not on the question of facts, because whatever facts you have presented, that already you have presented. You cannot change the facts that you have presented in an appeal. Only thing that works in an appeal is there is a question of law, because based on these facts, law has not been served properly. That is all you can say. So if you have hired a better lawyer in an appeal, there is only little that he can do when the facts were not properly presented in the first place. So it is very, very important that the first shot should be your best shot, and even in the initial phase, you should hire the best lawyer. Now, rule 4 is, you should, as far as the legal notice is concerned, you should sit and communicate everything with the lawyer. Because you cannot just give the legal notice that has been served to you by the patient, the lawyer, and say, you please reply. Because he does not know anything about medicine. You have to start from zero. You have to tell him what cornea is, what retina is, what this particular disease is, why he has given a complaint, and and convince him that you are in the right, you have taken all precautions. And you have to say things in very simple terms. Don't use complicated terms, and do not take things for granted. You should not be talking to the lawyer as if you are talking to your PG student, that he understands everything that you say. So the important thing is be very crisp, simple, communicate everything to the lawyer so that he can give a proper reply to the legal notice. The importance is, suppose a very good reply is given to the legal notice served by the patient's lawyer to you, the patient's lawyer and the patient will understand that there is no point in me going ahead with the case, because the doctor has done everything for me and there is no way I'm going to win this case. So many a time the case gets stopped at that phase itself. It never goes to court. So that is the importance of educating your lawyer about the particular case and giving a proper reply to the legal notice that your patient or the complainant has served to you through his lawyer. Now, very, very important thing is, one thing is this V. Krishnakumar versus State of Tamil Nadu. This is one of the landmark case where Children Women Hospital in Chennai, where an award of 1.38 crores was awarded for medical negligence in an ROP case. See, one thing you must understand is, at that time, there were not even enough ROP screening guidelines available. It was at that time that, medical negligence for ROP was established. So that just shows that even in the initial phases, the case was not run properly by the lawyer. That is the importance of giving the first shot, the best shot, and employing the best lawyers even in the beginning. Okay. Now the legal notice has been served. You have given a reply. Now the patient can have two courses of action. One, he says, okay, the doctor has given a reply to my legal notice, and I'm convinced that the doctor is not at fault. There is no point in me going ahead with the case, and that will be the end of the story. The second course of action is, seeing the reply, the patient feels the doctor is trying to roll around. He is still in the wrong. I am going to approach the court. So what he does, he will go to the court. I told you in the earlier talk, civil court, criminal court, consumer protection forum, whatever court, he will go to the court. Now the court will see the complaint of the patient. And if the court feels that there is something there in that particular complaint, what the court will do is, it will send you a summons. Okay, a summons means it is a legal document or a legal communication sent by the court, asking for your presence in the court, or it is like asking you to give a reply to the complaint filed by the patient in the court of law. The complaint filed by the patient in the court of law is called as a plaint, and the complainant is called as the plaintiff. Okay, and the person against whom the complaint is filed is called the defendant, and the reply given by the defendant what you say, against the complaint given by the plaintiff or the complainant is called as written statement. So that is what I said. When you receive summons, you have to give the reply within 30 days or maximum within 45 days. So this reply that you're giving is called as written statement. So you should sit with your lawyer, prepare a detailed reply, because the lawyer will not keep on reminding you. And it is your case. I told you, lawyers are not like doctors. They are not like, they'll not go behind your patient, make sure they are okay. It's not like that. They have hundreds of things to do. If it is your case, you should be aware of it. And well, within that 30 days time, you should sit with your lawyer, prepare a detailed reply, which is called as written statement, and file the reply in the court of law on time. So what should be there in your written statement? It should be based on facts and the evidence you have, and you should avoid admissions and unnecessary statements. Now, another thing is, when you're interacting with the lawyer, you should understand lawyers are very suspicious people. They will not believe you. So even if your lawyer doesn't believe you, don't worry, don't get emotional, be objective, state your point of view in clear, simple terms. Now I told you about written statement. The written statement goes to the court of law. And another thing, as far as doctor-lawyer interaction is concerned, is, see, you have your lawyer. He's the best lawyer. You don't have access to lawyers just like that. You cannot just call a lawyer and talk to him, because he'll be busy in 100 places. Their style of functioning is totally different. So whenever you have a case, you should get hold of a person in the lawyer's office who is always accessible. He may be the junior of that particular lawyer, so that you can always communicate things to his senior and get your point of view across. So that is also very, very important. Try to establish a liaison or a point of communication in your lawyer's office. Then I was telling you about filing the response of time, and don't think that lawyers will keep on reminding you regarding that. Very important. So this filing the response of time filing response in time has been established by a case law in the Supreme Court, because after 45 days, the court is not going to hear your point of view, because the chance for your giving a reply is lost if you exceed the period of 45 days. Then, once this written statement is given, the patient or the complainant, has a right to refute your reply. That is called as a rejoinder. So he will file another statement or another document in the court saying that whatever things that you have said in reply for his complaint is wrong, this, that, and all. He will give a reply. That's called as a rejoinder. Okay. And the next phase is filing of evidence. Okay. So the next thing is, what you should do is, the patient will file all his evidence, whatever documents he has, he will file all his evidence. And the second thing is, the patient will try to communicate another doctor who has an expertise as you in that particular field, and get a report from him in their favor, saying that things should have been done like that, and you have not done like this. I mean, you have done like this, and things should have been done differently. So that is something called as an expert opinion or an expert witness opinion. So usually the patient gets an expert witness opinion to prove his case against you. As far as you are concerned, you don't need an expert witness opinion, because you are already the expert. But it is always nice if you can have some of the experts in the field trying to give a report in favor of your particular case. Now, whenever you are filing an expert opinion, it should be filed as an affidavit. Affidavit means it is not that you simply write in a statement and just sign it. The doctor who is giving the opinion writes a few sentences and signs it and give. It is not like that. It should be given in the form of a sworn document. It is saying that, it is with my full knowledge I am writing it. I know this person, whatever I am saying is true, and I am ready to live up to this statement if I am called in the court of law. Anytime I will come to the court of law. That's called as an affidavit or a sworn statement. So whenever you are filing an expert opinion, it should be in the form of an affidavit in the court of law. So that is also going to help. Then another thing is there is something called as hearings, because you will be called to the court from time to time. See, that is different in different courts. In the district forum and the state forum, you have to go in person. You have to go as a witness. You will be cross-examined, examined, etc., etc. But in the National Commission, it is only through interrogatories. Like, you don't have to be present in person. It is all like if you want to ask questions to the complainant, it is all you should write the questions and file it in the court of law. The court of law will give it to the complainant, and the complainant will write the reply and you will get a copy, and the other one will be filed in the court. The same thing will happen if the patient's lawyer wants to ask questions to the defendant. He has to give a set of questions which will be given to the defendant. He has to give answers, and it will be filed in the court of law, and one copy will be given to the complainant. So it is like that. So there is nothing like like you say, in-person things. The doctor, the complainant, or the defendant going to the court and being examined in the court of law, cross-examined in the court of law is not present as far as the National Commission is concerned. Only in the state and district forums, in-person examination and in-person examination and cross-examination, chief examination and cross-examination happens in person only in the state and district forums. In the national forum, it is not like that. See, I told you summons, hearings, etc., etc. I mean, these are all times when the court will ask for your attendance. The court will ask for your attendance in the court of law, so that you can stay your part of the issue, and you will be examined or chief examination or cross examination by the lawyers concerned. So for forcing your attendance in the court, summons will be served. See, in the initial summons, if you don't go, you will get a second summons. Again, if you don't go, you'll get a third summons. If you don't go in third summons, you can be arrested and be presented in the court of law. So it is always better to attend all hearings on time and go in the first instance itself. Because if you don't go in the first instance and if you go in the second instance, the judge usually doesn't like it. What he will do is he will make sure that in the second instance, you are the last to be called, because it is like, you have not been respectful to the court in the first place. That is true, because you have been called and you have been negligent and you've not attended the summons on time. So it is very important that whenever you get a summons, you should immediately go attend on time, so that it makes life easier for you. And always be truthful. Another thing is you should pay your fees on time. That is also very, very important, because the interest of the lawyer depends on all these things also. So there is an interesting statement by Advocate Harish Salve. He says, I charge a reasonable fee, which is fairly high by standard. So you know what kind of fees lawyers charge these days. Thank you for your kind listening. And the only thing I would like to say is these are the processes involved. And once you have filed all the evidences, the general examination, cross-examination, all these things are over, there will be a final hearing. In the final hearing, both sides will be heard by the judge, and a final judgment will be given, or a decree will be passed. And if that decree is not favorable for either of the party, or always will be favorable only to one party, whichever party is not happy, he can go for an appeal to the higher court, and he can go up to the Supreme Court, and whatever judgment is given by the Supreme Court will be final. So that is how this process of law occurs as far as a medical legal case is concerned. It is a very, very, very tedious process. It brings you a lot of mental trauma. It will make you feel why I chose this profession, but it doesn't matter. That is how law works in this country. It gives a chance for everyone. And it is the right of every citizen to have a complaint against the other. So you should take it only in that spirit. You should stick to your guns. You should present your evidences well. And I am sure if the doctor has not been negligent, he can come out with flying colors, because most of the negligence cases, the doctors are not convicted, because most of the time they are in the right. Thank you very much.
Thank you, Dr. Nataraj, for so expertly taking us through every step of handling a medical legal case. You told us step by step what to expect and how to tackle it. So kudos to you. Thank you for that very, very nice talk. So since we are already, I mean, I think we've already crossed the time. I'd like to invite a few quick comments from Dr. Prakash Marathe, sir. Anything you'd
Yeah,
like to
madam,
add?
thank you. Yeah, I will be very like for this particular session, most of the juniors, ophthalmologists, even seniors, they may be in bad frame of mind. But just to avoid all these medical legal litigations, you must have friendly doctor-patient relationship. That is one thing. Second thing is you should have very good chair time. You should have very good contact with your patient and relatives. You should be respectful. You should be your relations should be cordial with your patients and relatives. That's what you have to remember, and that will avoid medical legal litigations. Suppose by chance there are medical legal litigations. Simple thing I'll tell you. Your friend is Dr. Ashok Natraj, who is the lawyer, but he cannot be there in the court on your behalf because he is a doctor. And doctor, though he is a lawyer, he cannot be present in the court of law and can't defend your case. So if at all he has to practice as a lawyer, he has to resign from his medical profession. So you have to go to the lawyer, but you cannot go to medical legal expert, but you have to take help of medical legal expert. So please take help of medical legal expert like Dr. Ashok Natraj and then go to the lawyer. So you are in connection with the lawyer via medical legal expert. That is the second thing you have to remember. So practicing lawyer, practicing doctor, these are two different things. And medical legal expert is the person who can help you if he is practicing doctor, cannot present in the court of law your case, or if he is medical legal expert but practicing in the court of law can take your case directly. This is the thing you have to remember. Other thing is about fees. Unfortunately, in the medical profession, government is trying to cap our fees. Like there are so many issues like consulting fees, operative fees, but like lawyer profession, there is no capping. So if there is no capping for lawyer profession, architects profession, engineers profession, why should be there like capping for medical profession? And most unfortunate thing is like Consumer Protection Act is applicable for noble profession like medical profession where lives are involved, vision is involved, and lawyers are not coming under that Consumer Protection Act. This is the pity of our country. This is the pity of our profession. But the sky is not that dark. So you should be hopeful, and I expect everyone for very good healthy practice without any medical legal litigations. Thank you.
Thank you, sir. Dr. Moray, you'd like to add something?
Yeah. So I won't take much of your time. So regarding the disparity between the compensation. So July 2015, Justice J.S. Khair and S.A. Bobde, they passed this 1.3 CR compensation versus the Tamil Nadu government. In 2016, 6619 civil court against hospital in New Delhi, the compensation was 76 lakh against the same problem, ROP. In civil court, Jaipur, it was 23 lakhs. So why this much of disparity? For the same means negligence with the same disease of ROP.
Dr.
Marathe,
Natraj, would you like?
You are asking question? Yeah, okay. Dr. Natraj, if you can answer, otherwise.
Dr. Natraj, would you like to answer? Why this disparity in the compensation?
Compensators can depend on person how could have
I'm not able to hear you.
depends on lot of
I think he's lost connection.
Marathe sir, could you
I
please?
think it is the profession of that particular person, age of that particular person. So for that particular age, what his profession is there, what he could have earned in his lifetime. Suppose the vision would have been good. These are the things which are taken into consideration: profession, age of that particular person, and the severity of that particular disease. Like whatever negligence has been proved, severity of that negligence, whether it is in both eyes or only one eye, grading of that particular blindness, that's what I feel. Because of that, the compensations may be different. Again, there is contributory negligence. That's what Dr. Nataja said. Probably it is the sharing of that particular compensation in doctors who are treating. Probably when it is a surgery, I think the person who is doing surgery as well as anesthetist, then the hospital owner, and so many things. If it is divided, again the compensation may be little different. Like 11 crore case which was there in Kolkata, the doctors, that 11 crore was not from the doctor's side. I think hospital management was punished and much more amount was awarded from their side.
Thank you, sir. Dr. Kedar, would you like to give any inputs or add anything before we wind up?
Unmute. Dr. Kedar, unmute yourself.
Unmute.
Hello. In
Yeah.
cases of ROP cases, most of the contributing negligence also from parents, from the child also. So you should actually give the regular advice for the parents to come to follow up for the with the child to the hospital. That is also very, very important point.
And
Thank
that
you.
I will
needs to
just
be
add one thing
documented.
here. I'll just add one thing.
Sure,
That
sir.
5/9, today's date is 9/5. So 9/5 is 9th May. It is American style. It is written opposite, 5/9. So you have asked
Yeah,
the patient to come on 9th May and he may come to you
yeah.
on 5th of September. So it is very
Mhm.
important. You should write this date very specifically with the month.
Yes, yes,
And
yes,
this has happened in case of ROP medical negligence, that the follow-up
yeah.
date received by the patient was little different. And that was the explanation given by the patient. For this particular reason, I came late to the hospital and follow-up was not proper.
Yeah. So the training of the staff is very, very important for the
Important.
documentation,
Correct.
because doctor will
Yes.
not do all the documents. Only staff will do the
Right.
documents. So that the regular training of the staff is very, very
Yes.
important for the awareness. Mhm.
Documentation extremely important. So with that, we come to the conclusion of this very, very excellent webinar. I thank Dr. Ashok Nataraj for all his expert guidance and inputs, and the two very wonderful talks. I also thank our expert panelists, Dr. Prakash Marathe, Dr. Kedar, Dr. Arvind Maurya, for all the knowledge, all the expert inputs and the insights that they shared. And whatever we've picked up from this webinar is how to tackle medical legal issues. But the two underlying things that we ourselves can do is, like Dr. Marathe said, have a very effective patient communication. And as Dr. Kedar and Dr. Maurya also pointed out, that our communication, our documentation should be, top class. So document each and everything that you've done, and keep the channels of communication open with the patient, so that you don't have to get into this rigmarole of medical legal hassles. So with that, I thank everyone once again, our speakers, our panelists, the audience, and I hope it was a very fruitful webinar for you. Thank you once again, and a very good night.
Thank you. Jai Hind.
Thank you. Thank you, ma'am.
Thank you
Thank you so
very
much
much,
for
ma'am. Thank you.
conducting it in a